Hello and welcome to the Herrington Carmichael Employment Law Update for February 2017. My name's Alistair MacArthur. I'm the head of the employment team with Herrington Carmichael, and as always I've got 4 key areas of employment law development from the last month. So where to begin? Let's start with pregnancy or maternity based discrimination. The government has published its response to the Women and Equalities Committee report from August 2016. This report recommended 21 different areas of development to law that they felt needed to apply. The government has rejected all of those, however, saying that they weren't necessary and the law already protected against discrimination in this field. The government did recognise, however, the need for enhancements to redundancy-based discrimination claims and women who face redundancy in pregnancy and maternity situations. We wait to see what happens with that, and as always we'll bring you updates as they come. The next is the Women and Equalities report in relation to dress codes. This was prompted by a complaint by Miss Thorpe in relation to a dress code which she felt was discriminatory and required her to wear high heels to work. Personally, you may have noticed I'm not wearing high heels today, although you can't see my feet. So what does this report say? This report basically says that discrimination should not take place in relation to dress codes, and what you should do is make sure your policy is as undiscriminatory as possible. That will seem obvious to many of you, but please go back, dust off your dress code policies and make sure they apply equally to both men and to women. The standards are the same and you make sure you're doing what is right. Next, employment tribunal fees. We have received the long-awaited government response to the report in relation to employment tribunal fees. These have largely been taken to be fine and acceptable and have not discouraged claimants from issuing claims. This has largely been supported by the great work ACAS has been doing in relation to resolving complaints prior to the issue of tribunal claims. The fee remission system is up to be reviewed to make sure it remains effective, but really this is telling us tribunal fees are here to stay. And lastly, we have the case of Adoskin and Sainsbury's, which relates to gross misconduct in relation to gross negligence in the workplace. In this case, Mr. Adoskin found out about a failure in relation to a report and did absolutely nothing about it. He effectively failed to act. That was found to be gross negligence, and the court held that ultimately this could also be gross misconduct and Mr. Adoskin could be fairly dismissed for that. This may again seem obvious to many of you, but really what it does demonstrate is employees cannot just sit on their hands. They do have to act if they see something inappropriate. But as always, we'd recommend that there are clear clauses in your contract placing obligations onto an employee to report their own wrongdoing. That's it from me this month. I hope you have a very good month and we'll be back in March. Thank you.